On the record, in the matter of the people of the state of Michigan versus Dayton Athlete 25-01673, council appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people. I do make a motion to practice under Michigan Court Rule 8.120. I have APA Ross Marchmino to my left.
Motion is granted today with, sorry, your appearance, please.
Assistant Public Defender John Lee appearing on behalf of Dayton.
Okay, Mr. Athlete was scheduled for a preliminary examination today for receiving and concealing firearms. Are we running an exam?
I do not believe so, Your Honor. The people are prepared to unconditionally waive the preliminary examination. I believe defense is going to as well.
That is accurate, Your Honor. We're gonna waive the examination.
Not offer.
There is no offer on this, Your Honor. I do believe that there may be a global resolution in circuit court, but there's no offer in district court at this time.
For negotiations to continue.
Yes, Your Honor. Also, we're also adding the felony firearm. Right.
We're not stipulating.
Right, but if you're still going to waive.
Yeah.
Okay, perfect.
How that works. He's not stipulating. You gotta have an exam if you want to add a count.
Okay, Your Honor. Just give me one moment.
Who's reviewed probable cause for it? You just can't add a count.
Then the people need one moment, Your Honor. I apologize.
1 moment for what?
I just need 1 moment
To see if we're running an exam? Or,
I just need 1 moment to convene with another APA.
oh, okay.
That's
Off the
all.
record. I'm trying to see if we're running an exam now. Okay.
Oh,
off the
okay.
record.
My apologies.
You can stay right there. I think she'll be ready in a moment. Wow, Mr. Abbott's still hanging out with us. Hey, Mr. Abbott,
Good morning, Your Honor.
how are you?
Well, and you?
Pretty good. Which matter are you here on, Mr. Abbott?
Yaki and Walker, the preliminary exam, and DeAndre Holmes, CCC, covered for Derek.
Oh,
Your Honor, the people are ready to waive without adding the felony firearm.
back on the record. Okay, so the parties are prepared to waive unconditionally. Counsel, can you approach? Thank you.
What's that?
Took the day off?
No.
Sorry, what was that? Thank you.
signed it already.
I-
Okay, Mr. Athlete? You understand that you have the right in this matter to have a preliminary examination because you're being charged with one felony weapons, firearm, receiving, and concealing, correct? Okay, you understand the purpose of the examination? Is that a yes? So you have the right to require that the prosecutor move forward with the examination and establish on the record that they have sufficient probable cause that a felony was committed and probable cause sufficient to charge you as the person who committed the felony. You understand that? Wish to unconditionally waive your exam? Is anyone threatening you to do that? Any promises extended to you if you waive your exam? I find your waiver to be freely and voluntarily made. The bind over date is going to be July 9th. That is the date the circuit court will receive the file from the district court. It is not a date that you need to appear in court, okay? Your next court date will be a pre-trial in circuit court. Your attorney will be made aware of that date, okay? So you stay in contact with your attorney. Do you have any questions at this time? What's your address? Your phone number ends in 9400?
9410.
Okay. Almost at a 2,000 personal recognizance that will continue. Any additional matters for the record?
Nothing on behalf of the people, Your Honor.
Nothing for the defense, thank you.
Thank you. You're all set. Is Mr. Mills across the hall? I saw him. He's got the DOC. I don't know if we're running that. State of Michigan versus Alexander Gifford, 25-01664. Appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people. Good morning, Your Honor. Attorney Andrew Lee, PH 4377, appearing on behalf of the state. Gifford, who stands to my right. Gifford, please say your full name for the record, please.
How are you both? Thank you. I'm well, thank you. Okay, today was scheduled for a preliminary examination on count 1, assault with intention to inflict bodily harm, less than murder, or by strangulation. Are we proceeding to examine?
People are unable to proceed at this time due to the unavailability of unnecessary witnesses, Your Honor. Based on it, Your Honor, we make a motion to dismiss.
The motion is granted without prejudice, so the people have the right to reissue discharge against you. Do you understand that? Do you have any questions at this time? We'll get you a copy of dismissal in just a moment. Any additional matters for the record?
Nothing on behalf of the people, Your Honor. No, Your Honor.
Thank you. On the record in the matter of the state of Michigan versus Mariah Kemp, 25-01666. Appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Good morning, Your Honor. This is the public defender, Aaron Schroeder, on behalf of the Kemp, who is present and now stands to my right. If I may have a moment, Your Honor, just trying to talk to the prosecutor just briefly here, if I may.
I'm on the record now.
Okay.
Are we proceeding to exam?
The author, you can get the authorization. Can we drop? Can we do that? That might break this.
So I was really sure that's where at 9 o'clock.
You don't think so? Okay. And
We're running an exam.
sounds like they may not have their officers here for the RNO portion, Your Honor, so I'd be moving for dismissal of all charges.
Your Honor, the people would need a moment to call these officers and get them here.
You mean the people need a moment to call the officers and get, were they subpoenaed?
They were, Your Honor.
We were supposed to be here at 8:30.
They were.
Absolutely. No, there's no moment to call your officers to get here. They know what time it's supposed to be. They get a subpoena.
Yeah, understood, Your Honor.
So, no officers on the PL assault. How do you want to proceed?
Your Honor, at this time, I would like to move to dismiss as to the felony charge.
The felony is dismissed without prejudice because the people are unable to proceed at this time. We will set the domestic violence for a date for a pretrial on our misdemeanor docket.
Your Honor, would it be possible to have that set for a final pretrial if this court does those?
Absolutely.
Thank you.
Final pretrial July 21st.
July 21st at 8 a.m. The final pretrial will also get you a jury trial at this time.
September 15th at 8 a.m.
September 15th at 8 a.m. for jury trial. Both the final pretrial and the jury trial, you must appear in person, okay? Do you have any questions at this time?
Your Honor, can I get those dates again? I apologize.
July 21st, 8 a.m. and September 15th, 8 a.m.
Thank you, Your Honor.
No problem. Any additional matters for the record at this time?
Nothing on behalf of the people, Your Honor.
Nothing to have defense. Thank you, Your Honor.
You're all set. We'll get you your notice in just a moment. Let's see, Mr. Starks.
He's down in Lockingham.
Okay, and then, okay, you have Google here?
Yes.
On the record in the matter of the state of Michigan versus Adam Gugamas, 25-01040.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of defendant Adam Gugamos, who is standing to my right.
Okay, Mr. Gugamas, scheduled for a sentencing today, and I do have a pre-sentence report. It was prepared on the 10th of June. Council, did you get a copy?
I did, Your Honor, and I've reviewed it with Mr. Gugamos. We have no need for any additions, deletions, or corrections.
You have to make allocation.
Thank you, Your Honor. In regards to the recommendations, we have no objections to them. I think that the probation department laid out some very reasonable expectations for Mr. Gugamos that he's well equipped to handle. Obviously, he has issues with some of the issues he has with housing and employment, that sort of stuff. He is working on trying to get his ID so that he can get a job. He's also working with community mental health already. So we feel that continuing with his, mental health treatment, also he can get outpatient substance abuse counseling through that same institution. So we find that these recommendations are very reasonable, and we ask the court to follow recommendations. The only thing I would add is that I know that there's no victim impact statement. Obviously, we're dealing with Mr. Gugamos and his mother here. He used to live with his mother. He was very close to her. Obviously, they've had issues, but as he works through probation, I just wanted to put on the record that we hope that him and probation department maybe can reach out to his mother and see what she wants in this regard, in regards to the no contact order and what she would want in that. But because that's the only thing that we were unsure of, is if there'd been any contact with his mother and what in regards to whether she wanted that no contact order. But if there has been no word from her, then, Your Honor, then we would have no objections to that recommendation. It's just that we would wish that something maybe can change while he's on probation. Thank you.
Did your client wish to make a statement at all? I reviewed the pre-sentence report and the recommendation. It's always unfortunate when the parties involved are family members, particularly when it's parent and child, because now there's a breakdown in the relationship. And so typically, the court would not ask or put it on upon the probation department to try and mediate that issue. She's not reached out to the court. This was not a matter of, I don't even believe did she ever appear in court? I don't believe so. Maybe she did at the time of the,
She did a good.
okay. I would imagine that if your mom wanted to work on your relationship, she would make some contact with the court. I don't know why she hasn't. I don't know that there was a request for a victim impact statement, so maybe that's why we don't have one. So what I will do is I will see if your probation officer can send a letter for her to respond to. So it's at her request. If she wants to have that no contact removed, she would need to contact the court, okay?
Yeah.
Okay, so with this being stated, I think that a term of probation is appropriate. Now, you said he's already engaging in some mental health, so that's good. He's taking his medication at this time. The order of the court is that you remain compliant with all of your mental health treatment and all of your prescribed medications, okay? While while you're on probation. And are you employed, sir?
Not financially. I work with veganism and volunteer veganism.
What's that?
It's hard to. It has to do with COVID, the whole thing.
Do you put in hours somewhere?
I every day. I enjoy what I do, so it doesn't seem like a job. But
That's good.
you know, I might go juggle somewhere with a V sign somewhere, or I associate with veganism and promoting health and stuff, and but I am gonna get a legit job, Dollar Tree or something.
Okay, yeah, that's definitely going to be the order of the court is that you get some employment
Yeah.
and that you earn a living for yourself, okay? Okay, so let's see. I'm ordering that you continue your treatment.
The veganism is volunteer, so we don't really get anything in return. So
Yeah, I was just wondering exactly what that was. You said volunteer veganism?
So basically you advertise, you spin signs and posters and stuff, or?
work online and just debate people about the benefits of veganism and stuff.
You do that online? Like
Yeah,
what, on social media?
yeah.
So like it's like a social media account and you like will go back and forth with people?
Yeah.
It's like trolling though.
It's a freestyle, you know. It just pops up like.
Got it. And so if someone responds, then it'll be someone like you that is operating behind the scenes on behalf of the business about the benefits of being vegan?
Yeah, how it can help and
What are some of the benefits of being vegan?
it's sustainable, it's meant for everybody, it's it's how it should be.
So I assume you're vegan?
I have nothing coming in, so I take whatever's available.
Got it.
If I get a free breakfast that's not vegan, I'll take it, but
Your preference is to be vegan?
I've been vegan for 2.5 years.
Got it.
And
Okay, sounds good.
Yeah.
Thank you for sharing that. So like I said, I will have
I have gone 13 days vegan this month, eating out of cans.
Wow.
Yeah,
So you're committed,
yeah,
and
I
if your
try.
resources were, better, you'd be vegan, it sounds.
Yeah,
Okay. So again, I'm gonna continue the no contact order, only until, you can get some response from your mother, okay?
yeah.
While you're on probation, you're not to use, purchase, or possess any, drugs, alcohol, or marijuana unless you have a valid prescription. You're not to engage in any assaultive or threatening behavior. You're going to be required to submit to random preliminary drug testing and your analysis testing. And you have to pay the cost of that, okay?
Yes.
Okay, you're not to be at any bars or any nightclubs while you're on probation, and you will be required to obtain employment and maintain that employment, okay?
Yes.
You have any questions about probation at this time?
No.
So it's 8 months probation at $30 per month for oversight fees. So your probation fees are $240. There's a $75 crime victim rights fee that by statute I must assess, and $50 state minimum cost that by statute I must assess. However, I will waive any additional fines and costs. The total fines and cost is $365, but you'll be able to make monthly payments on that, okay?
Yes.
Lastly, this is an advice of rights for probation. It advises you of how you may request early discharge from probation. Once you've completed half the original term ordered by the court, if you've not made or had any violations within the 90 days prior to that request, you can use the court's MC 512 form to make a request for early discharge from probation. You would file a copy of your request on the prosecutor's office and a copy on the probation department. The prosecutor has 14 days to respond in writing with any objection to your request, okay? Is that, okay, if I set up for a hearing, you have the right to have an attorney represent you, but you would have to hire the attorney, okay?
Yes.
Do you have any questions at this time?
No.
We'll have to check in with probation before you leave. Any additional matters for the record?
Not from the defense.
Nothing having after people, Your Honor.
Thank you. You're all set. Record in the matter of the state of Michigan versus Terrence Finley, 23-00746, appearance, please. I'm gonna say appearance, please, and then people will have a conversation. I said appearance, please, like,
Sorry, Your Honor.
I apologize, Your Honor. Good morning, Haley Fortuna Gill on behalf of the people.
And good morning, Your Honor. Stephen Mills on behalf of Mr. Finley. Mr. Finley is present and by right this time.
okay, Mr. Finley has a preliminary examination for identity theft. Are we running an exam today?
Your Honor, actually, if I could have just a few more minutes to speak with my client, we just learned some new information at this point. I literally need just 5 minutes.
I'm waiting.
If that's okay?
Yeah.
Oh,
I don't think
great.
I have a choice.
Sorry.
I'm waiting.
Thank you, Your Honor.
Anybody see Mr. Search today? I haven't seen him. I've seen him.
Oh, yeah, actually,
He was downstairs.
yes, he was waiting to get into the lockup. Hey, there you go.
Who is it? Oh, I see Miss Wanji, but she just stepped out. Mr. Sarts is on Milner. Are we ready to bring him up? Mr. Sarts, Milner? Oh.
I'm ready on my end, Your Honor.
Oh, my thing said, that's Mr. Milner?
No, she needs to speak to me.
Oh,
That's gonna be a 5-6 count prelim, Your Honor.
that's why I'm wondering if you're ready, we're running the exam for Milner, correct?
Your Honor, I just need a moment to make sure that these officers are who I need for that case. A bunch of officers showed up for the 9:30
Mr.
docket.
Bierman?
And Mr. Sargent, I vote.
Yes.
Thank you.
Okay, back on the record in the matter of Mr. Finley.
Yes, Your Honor, we were ready and we were planning on running this examination. Your Honor.
Okay, how many witnesses do we have?
Just one witness, Your Honor.
Okay, you can get prepared. Mr. Nagel was here on which one?
On Yaki.
I don't see Miss Wanji, so. And Ms. Schroeder has Morrissey and Schneider.
Morrissey, Schneider, dropping,
Oh,
and
boy, you got a lot.
yes, I did.
Morrissey's running or no?
Morrissey's gonna request for a very, very brief adjournment, Your Honor, due to some information I received from my clients today.
On the record in the matter of the state of Michigan versus Melissa Morrissey, 25-00278.
Just one moment. I'm so sorry.
No problem.
Broke out the mom voice for a second.
That's exactly what happened.
First name.
Okay. And council appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
And thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Ms. Morrissey is present, stands to my right.
Okay, Ms. Morrissey was scheduled today for preliminary examination and retail fraud. My understanding is that we will not proceed at this time.
That is correct, Your Honor. I've consulted my client. I've also talked with Ms. Fortuna Gill. Ms. Morrissey has indicated she wishes to have some additional time. She has family members who are wanting to review the offer further with her. I became aware of this morning. As I do know, it's a retail fraud. It's an older matter. I do acknowledge all of that. However, I would ask the court to allow for a brief adjournment. I don't believe this is eventually going to end up in a preliminary exam stage, but I would, in terms of the actual running, but I think if Ms. Morrissey would like some additional time. Thank you.
My first retail fraud from South Pennsylvania exam, if that were to go. I've never had, but you never know. Okay, so you want more time to consider. There was an offer, I'm assuming, that was extended?
Yes, Your Honor. There was an offer to retail fraud second.
Okay,
The people do have a witness here. The people are prepared to proceed. That being said, the people do not object to Ms. Schroeder's
so
request for an adjournment.
the offer, I'm sure, is only good until the exam is run.
That is
correct?
correct, Your Honor.
Okay, so you want additional time to consider this offer and discuss it with your family, correct? Correct. So you understand, though, that you did have the right to have your exam within 21 days of the date that you were arraigned. So if I extend this, you would have to waive that timeline. You understand that? So I can, because the right, you have that within 21 days is your right. And so you either have to waive it or I have to find good cause to go beyond the 21 days. You're requesting their adjournment or the additional time. So are you willing to waive the time frame so that I can reset this for you?
Yeah.
Okay, and no one's threatening you to do that, correct?
No.
July 18 at 10.
July 18th at 10. Get you a notice to appear. Do you have any questions today, ma'am? Okay, any additional matters for the record?
Nothing on behalf of the people, Your Honor.
Nothing to behalf of defense. Thank you.
Thank you, you're all set.
Morrissey, Melissa, 23, yeah. I'll send you some more information.
That was more mistake.
Okay. All right, I will email it to them. Okay. Thank you. You are good to go once you get the notice.
What are we doing on Schneider?
That is, she is here, Your Honor. I believe there may be a screening that, now that she's out of treatment, possibility for the sobriety court here, but because she's been in treatment for quite a bit, we're not able to complete that yet. We'll be asking for some additional time.
Okay, on the record in the matter of the state of Michigan versus Ferris Schneider, 25-01090. Yes.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
And good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Ms. Snyder, who is present, now standing to my right.
Okay. I can see that she was up in some treatment. Okay, so today was the date scheduled for a preliminary examination. This was for a OWI third. A timeline has already been waived. My understanding, though, and even from the notes, is that there was an offer for sobriety court, so we need time to go through that paperwork and process. Sounds going on.
Yes, Your Honor, and I will note that as of May 5th of 2025, Brianna Kosh Schneider indicated
way back then that she was eligible, appears to be eligible for the sobriety course. We just need to get that paperwork done now that she's back.
August 15th at 9:30. August 15th at 9:30. Get your new date, ma'am. Do you have any questions? Okay, any additional matters for the record?
Nothing on behalf of the people, Your Honor. Nothing on behalf of defense, Your Honor.
Thank you. You're all set. That's versa.
Yes.
Thank you.
On the record, in the matter of the state of Michigan versus Travis Verser, 25-01678, appearance, please.
Berman on behalf of the people.
Good morning, Your Honor. Jacob Starks, the fourth Assistant Public Defender here on behalf of Mr. Verser. He's at council table. He's standing to my right.
I also have 25-01680. I think I only called one case. Okay. Today was the date scheduled for preliminary examinations on both files, and how are we proceeding?
Thank you, Your Honor. On behalf of the prosecutor's office, Your Honor, all my witnesses appeared today, but two that did indicate to me they would not be available. They were the two on each file who ran the TrueNarc. And so I had all my other officers here who could testify, but we would have to come back just for that TrueNarc testimony. The other issue that we have on the 8.0 file is there's 139 files on evidence.com that Mr. Sarts and I have painstakingly between yesterday and today try to figure out why it appears as though he doesn't have those, whether they were shared with his office and not downloaded to his file or not shared with his office. And that pertains to the 8.0 file. So I'm asking the court to reset this on a day we do it all at once with everyone here, and to find good cause to do so for both of those reasons, to waive the defendant's 21 days and have it set all at one time. And then we will figure out the discovery issue. But I did want to state for the record that the fact that those witnesses aren't here are attributable to them.
Thank you. Mr. Sarts?
Thank you, Your Honor. Mr. Verser is still very insistent that he would like to proceed with his preliminary examination this morning. We have discussed the issues with the discovery, but he is very insistent that he wants to proceed this morning. If Your Honor is inclined to grant an adjournment on good cause grounds, respectfully, I would just request an opportunity to address his bonds. Thank you.
Can I just add one other thing, Your Honor? The defendant has a case pending in circuit court with Judge Aquilina. Possession with intent to deliver meth, possession with intent to deliver cocaine, gun charges, 6, 7, 8 count information in circuit court that's reset in Judge Aquilina's court, not until September. So I just wanted the court to be aware of that as well.
What's the bond on that matter, you know?
He is currently on his own recognizance on that matter. Judge Aquilina is awaiting disposition of these pending matters before she makes a decision in terms of how to proceed with that bond. But right now, he currently has 2 holds related to his cash or surety bonds in these respective files, Your Honor. Thank you.
Okay. And so, Mr. Versa, you would like to continue with your exam today. However, we have 2 unavailable witnesses. Not 2 witnesses that are not willing to participate, they're unavailable, and that happens. And when that happens, the court finds good cause to reset that. So I could start it today, but that's not really in the court's best interest. It's not in your best interest. If it's a possibility, if it's better to, or if it's the opportunity to have it all in tandem at the same time, that's what we want to do versus breaking up the evidence. And so I would prefer to just wait and not start and then still have to come back here for 2 officers. The other thing is you should not be running an exam if your attorney is missing 180 plus pieces of evidence. So that's definitely a disadvantage to you because your attorney has not been able to see what's in there. And there could be a load of defenses in that evidence for all we know. So you need to allow him time to get that and go over that with you to help present your defense. So for that purpose, I am gonna find good cause on both files to reset these.
Thank you, Your Honor.
And I agree. August 21st.
August 21st works for you at 9:30.
Should work for the defense, Your Honor.
It's fine, thank you.
May I be heard on bond, Your Honor? Thank you, Your Honor. Respectfully, on behalf of Mr. Verser, I would request reduction in this current 25,000 cash surety bonds on both respective files. Mr. Verser is not a flight risk. He has a job in the community. He lives in the community. He has an excellent record of showing up for his court dates. He will comply with all the court's orders. He will make sure he follows up with pretrial services. And respectfully, this could be quite a lengthy process here, Your Honor. Financially, he's in a tough spot right now. He doesn't have a lot of resources available for him. Otherwise, he would have posted his current amounts. And respectfully, Your Honor, I just would request reduction in the current 25,000 cash surety bonds on both of these respective files. Thank you.
Thank you, Your Honor. Obviously, the part of the reason why we're adjourning is on behalf of the people's witnesses not being here. So I leave it to the court's discretion. I do point out to the court, as stated, the defendant was on bond when he committed these or allegedly committed these two crimes. And I know from one of the reports, and it's on the 8-0 file, he told one of the officers that he doesn't live at 544 Baker. He doesn't live at 4311 West Michigan Avenue. He lived in the streets, although he sometimes stays at 544 Baker. So that was what he told the officer in an interview on the 8-0 file. And so the fact that he's got a good place to live and an employment, I find somewhat suspect, but leave it to the court's discretion.
Mr. Verser would just also like the court to know that he's also taking care of a young daughter as well. So he's very concerned about her. And if he's released, he would make sure that he can help take care of her as well. Thank you.
How is he taking care of a young daughter if he's living on the streets?
I can speak.
That's
Okay.
you.
Yeah, I don't live on the streets. My address is 4311 West Michigan Avenue. That's where I stay. Or if I'm not there, I'm at 6251 Balfour. That's where my daughter stays. Then the two addresses that I got, that's where my mail goes. So one of them is my father's house, one of them is me and my daughter's and her mom's house. So that's my address. So I need to be there or the other place.
Okay, the 4311 West Michigan, whose address is
That's my
that?
father's. They've been residing there. Haven't been in trouble since 2005.
In the 5,
6251 Balfour. That's Lansing, Michigan 48911. That's me and my daughter's mom. Her name is Michelle Knotts.
when you say me, are you on the lease?
But she's on the lease, but I
I didn't ask if
okay.
she was.
Okay, yes.
Are
ma'am.
you on the
No, ma'am.
lease?
No, ma'am.
Okay, so it's her house.
It's her house. It's her house. Yes, ma'am.
Okay. Is she present today?
No, she's at work. She's at work right now. So,
Okay, okay, and so you're not married to her, correct?
no,
Okay, where do you work?
but I drive my CDLs, so I drive locally around here in Lansing and Michigan. I drive
Locally, you say?
Yes, ma'am.
Like a truck driver?
Yes, ma'am. I was driving across country. I got a career. I just came back to Michigan to be with my daughter and her mom. So I did this trail tracking incidents happening back to back that honestly really don't. I know this ain't the part that you choose to be guilty or not, but didn't have nothing to do with me. A lot of it.
You got a good local job.
Right. So I got a good local job. Been working locally to help take care of my daughter. That's my heart. She's with me all the time.
So you have a truck, you're delivering for who though? Like companies?
Yes, I deliver to certain companies. Yes, ma'am.
Got it, okay, and so you're not eligible for a PR bond because you were already out on bond when these alleged cases were submitted, so you would not be eligible. I think the people did submit a bond recommendation at the time of the arraignment on both of these files, requesting the bond that was set, high cash surety bond. I think one request was for 75,000 cash surety with GPS tether. Yes, and that's on file number 1680. However, the magistrate went substantially lower than the request and issued a bond of 25,000 cash surety. The other bond recommendation was for 25,000 cash surety. Says defendant is on bond for 8 counts of various delivery manufacturer offenses and firearm offenses. So these are very serious actions. These are actions that are a detriment to the safety and security of the public, both drugs and the allegations of guns. And so my inclination as someone who is focused on running a business and taking care of a child should not have 3 pending felony files, all with similar charges that they were possessing and or delivering narcotics. And 2 of those files with weapons. I think the bonds were appropriately set. Do you have a question?
No, I was just gonna, another question. I was gonna say something, but.
Well, yeah, if your attorney doesn't think you should say it, that's
Okay,
that's for you
Okay,
and your attorney. I was gonna say, I believe that the bonds are appropriately set. Both of them require a GPS tether. No, I think only one requires GPS tether. I do understand, however, that there's gonna be a little bit more time needed to flush these out. I'd be willing to reduce the bond to 15,000 cash surety and file number ending in 80, 15,000 cash surety and file number ending in 78.
Wonderful. Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
GPS tether is still required. And we need a valid address that you would be staying at. I'm assuming you're gonna be staying at, you're saying 6251 Balfour.
yes, ma'am.
Okay, but you want your mail to go to
No,
4311?
the mail could go there too. I was just saying, that's where, I was just saying, that's the spot where my mail was going to. But yes, the mail could go to 6251 Balfour also.
All the bond conditions will continue. Any additional matters for the record?
And on behalf of the people, thank you, Your Honor.
No, Your Honor. Thank you.
Thank you. Okay. One second. I think you're ready. Back on the record in the matter of the state of Michigan versus Terrence Finley, 23-00746.
Haley Kristen Gill on behalf of the people.
And good morning, Your Honor. Stephen Milks, on behalf of my client, Finley, who is present and about to receive my right. It's okay.
Okay, and so we are proceeding with the exam at this time?
That's correct, Your Honor, yes.
Okay. Preliminary matters before we call witnesses.
Nothing on behalf of the people, Your Honor.
My understanding is only one witness, Your Honor, so not requesting sequestration.
Sounds good. You can call your witness. You can have a seat, sir.
People would call John Fiddler to the stand.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury?
So help me God.
You can have a seat, sir. Have you testified in court before?
Never. Well, I think I've had once,
Okay.
many years ago.
Okay, so there's a microphone in front of you. The purpose of that microphone is so that the lady behind you can capture everything that's stated in the court today. And so it doesn't amplify your voice at all. We got some fans going. I got this plastic thing here. So they're gonna ask you most of the questions. But your answers are actually for me to hear. So please try to keep your voice loud, or you can feel free to turn like that if that helps too. If there's an objection from either side, you will stop speaking. I need to make a ruling on that objection, and then I tell you if you can give us that answer or not, okay?
Okay.
If you don't understand or hear something, you can ask to have the question repeated. And state your first and last name. Oh, the other thing is, we need yes or no responses.
Okay.
So, because we can't really articulate into the record, mhm, uh-hs, or head nods,
Okay.
okay? So you might hear us if you are someone to do that, say, is that a yes, okay?
Okay.
State your first and last name, spell both.
John, John, Fiddler, Fidler.
You can see counsel.
Hi, Mr. Fiddler.
Hello.
How are you today?
Not so well.
Not so well. Can you tell me why?
I had to travel 7 hours yesterday because a gentleman has a state of Illinois driver's license with
Objection, Your
my
Honor.
information. And
This is gonna be evidence that is based on hearsay completely, regarding this information. And she's essentially asking me to narrate.
Well, I think she asked him why he wasn't doing well, and I don't really know that this is being offered for the truth of the matter asserted. I think he's just getting off his chest why he's not doing well. I'm not even taking notes right now.
Okay, because this is gonna be completely based on what I assume he's going to present to us.
Right, but he's gotta get something off his chest. He's wanting to explain why he's not doing well, so we're gonna allow it.
It's not for truth and matter asserted, Your Honor.
It's
Okay.
not, I'm assuming.
It's not, Your Honor.
I thank you.
Thank you.
You can proceed.
Okay. Reason I'm not well is because the gentleman, the defendant, has a state of Illinois driver's license with my personal information and his picture. Now, you can tell we don't look much alike. You might say he's more handsome than I am, but it's still, on November 1st, 2022, or am I?
Yeah, I can just ask you, I'll ask you questions. but
Okay, sorry.
I understand you're upset. That's okay. So,
And just the record clear, that none of that was for the truth of the matter asserted, is my understanding.
My understanding, that's just why he's not doing well.
Thank you, Your Honor. Appreciate it.
what about the joke about the handsome part?
We'll accept the handsome part.
So noted.
Okay, Mr. Fiddler, so, you said that you traveled 7 hours. Where is it that you live?
Springfield, Illinois.
Okay, and so, how is it that you know that the defendant in this case?
I don't.
Okay, so are you at all familiar with Terrence Finley in any way?
The only way I'm aware of him is through what I was provided. That he was.
In your objection, Your Honor, it's calling for hearsay at this point, is what's happening.
Did you want to respond to the objection?
Yes, Your Honor, I'm not sure what, I'm not sure what was, I don't know what was provided to him. I'm not trying to elicit hearsay.
You asked him, how does it that he knows the defendant? That was the question.
Yes,
And he's indicated he
He
doesn't.
said he doesn't know.
right.
No, so objection sustained.
Thank you, Your Honor. Mr. Fiddler, how is it that your license is missing? Your driver's license?
Oh, I've got my driver's license on me.
Okay, so what driver's license are you referencing?
I was told.
Objection.
Okay,
Thank you.
objection sustained.
Thank you, Your Honor. One moment, Your Honor.
Your Honor, may I briefly want to hear the witness, if that's okay? That's okay with the people.
Absolutely.
Fiddler, prior to today, have you ever seen my client?
Only his photo.
Okay. Have you seen his photo prior to today? Or I'm sorry, prior to this, you calling the bank?
Yes.
And you are familiar with how he looks? Is that fair?
Based on the photos from his previous crimes, yes.
Okay. So, and you received those through this investigation?
Yes.
Okay,
Well,
so-
prior to this investigation.
Prior to this
He
investigation?
was part of a
you-
ring that was circulating
So
with
prior,
fraud,
just prior to
and it was
this.
circulated to my credit union.
Okay, so prior to this investigation, you knew him personally?
No,
Okay.
I've never said
You
that.
just seen a photo of him?
Correct.
And
I've got the photos here if you'd like to see them.
No, I was just making sure that you do know who he is based only upon a photo. You've otherwise never met him. Is that right?
That is correct.
Thank you, Your Honor.
I could just have one moment to.
No problem.
Co-counsel, Your Honor.
Give me off the record.
Thank you.
All rise. Be seated. Yeah, sorry. Nice to meet you. All rise.
Okay. You can be seated. Right. You ready?
Yeah, the people are ready. Proceed, Your Honor. So, Mr. Fiddler, I know that you testified that you don't know the defendant at all in this case. So did you ever give him permission to use your information?
Absolutely not.
And, but did he?
Yes.
And, right. Did you ever receive notice of a transaction from your bank account?
Yes.
And was that transaction yours?
No.
And how much
Your Honor, I'm
money?
sorry, I'm gonna reject this point of relevance. I would just talking about some random transaction or something.
Are you stipulating that he took
Well, there's
$2,500
an
from you?
objection.
Sorry.
So I've got to make a ruling on the objection. Continue.
Sorry, irrelevance, Your Honor, just because at this point, we're just talking about some random transaction.
Okay, correct. You didn't really specify what transaction we're talking about here. You just said, did you ever get notified of a transaction? Maybe something more specific, maybe a date and time, an amount of a transaction.
Sure, Your Honor.
Thank you, Your Honor.
Okay, Mr. Fiddler, did you receive notification of a transaction on November 1st of 2022?
Yes, I did.
Okay, and how much money was involved in that transaction?
$2,500.
And did you make that purchase?
No,
Okay,
it was not a purchase, it was a withdrawal.
But there's no question. So that's tricky.
what were the details of that transaction?
Okay, on November 1st,
Your Honor,
2022.
sorry. This is gonna be hearsay at this point, once again, or at least no proper foundation made it. He's talking about an out-of-court statement being used for the truth of the matter asserted here.
Did you want to respond?
Yes, Your Honor. This is being used for the effect on the listener, not for the truth of the matter asserted.
Okay,
Okay, objections overruled.
not the truth of the matter asserted. Okay.
You can continue.
You're the best. Yes, we're prepared to continue, Your Honor. Right. Mr. Fiddler, did you withdraw $2,500 on the date of November 1st, 2022?
No, I did not.
Thank you. No further questions for this witness at this time.
Cross-exam.
No, thank you, Your Honor.
Your Honor, at this time, may this witness be excused.
Just give me just a moment. I'm just writing a note. Okay, I'm just trying to be clear that I have information here. What was the name of the bank? Your bank, sir?
My bank is Heartland Credit Union, but was withdrawn from,
Heartland Credit is your bank?
yeah, but it was withdrawn through shared branching network through the, I think it's
Okay.
adventure.
That
Credit
wasn't,
Union.
I just need you to answer my question. I just want to know what bank your bank was. Okay, it's Heartland Bank. And so you got contacted by Heartland Bank?
I looked at my account. and saw
Oh,
it.
you logged into your account.
I
Okay.
work at the credit union.
You work at the credit union.
That's how I caught it.
Okay, some stuff's coming out here. You work at the credit union, you were looking at your account? Is that a yes?
Yes.
Okay, and then you noticed something that
Strange.
was not familiar?
Yes.
Okay, did you contact law enforcement or did they contact you?
I first notified the officials at the bank to let them know that fraud had been committed on my account.
Okay,
And they traced
and
it
they
back
did like
to
a fraud, they did like a fraud investigation.
Yes, I did file
Okay.
a police report.
Sounds good, that's all I need.
Thank you, Your Honor.
You may be excused, thank you.
Your Honor, at this time, the people are going to request a continuance. The people do need the, after the testimony that came out today, the people do need to get the employees from this credit union here to continue this exam. That being said, Mr. Fiddler did travel from Illinois, so we did want to continue and finish his testimony today.
The employees of the credit union that he works at, you mean, or another credit union?
The branch here.
Oh, it's not Heartland, it's another credit union.
Yeah, but yeah, it's like a shared parent company type situation. That was confusing.
So the only witness that was subpoenaed today was
We did
Mr.
have,
Fiddler?
that is not correct, Your Honor. We did have 2 eyewitnesses subpoenaed. I have not been in contact with them. We need them to identify Mr. Finley. I'm not sure why they were unable to attend today, but I need to get another employee from that bank here, then someone that can be here.
Okay, but the employees of the bank would not be able to identify them. Is that what you're saying?
They should be able to, from the withdraw, from the. I do apologize.
So the two, well, it's not your fault, but the 2 people that you subpoenaed to identify are not here. The 2 people that did not show are not the people that you need to now subpoena. It's just separate people, because that's what I'm trying to put, correct?
I need a moment to confirm that.
And he's in the Department of Corrections until when? Because I had his earliest release date was in April, so.
Your Honor, yes, his release date was back in April. The report is correct. However, it's because of this pending case that he was denied parole. In full
This is
candor.
from 2023.
Sorry, Your Honor?
This is from 2023, though.
2022.
Well, but it was issued in 2023.
Yes, Your Honor. And in full candor to the court, Your Honor, on May 1st with the PCC, it was the defense that requested an adjournment for my client's request. Just so the court's fully made aware of this, but addressing this at this point, Your Honor, the people didn't even have the preliminary examination last time. They've had essentially what is a month, almost 2 months, Your Honor, in order to prepare for this today. I don't know if people are saying that they can't find these witnesses or if service was proper and they were properly served and decided to not show, or if there's any sort of follow-up whatsoever here, Your Honor. I mean, this is the biggest reason we're running the prelim today is because they couldn't make their proofs. And we were ready to go at this time, Your Honor. So I'm asking the court to dismiss this case.
Your Honor, the people do need Miss Jessica Haynes or Basil Ganem. It sounds like, it looks like on my end that they did get subpoenas. That being said, I have had several witnesses this week tell me that they didn't receive their mailed subpoenas. I don't know why. I'm not sure what's going on with that. It's not that I'm unable to get a hold of them. And the people are prepared to reissue on this charge.
Oh, so he's currently serving for that's November 2022. I don't see a release date on it. This maximum sentence 5 years. Okay, I'm going to grant the request for a continuance so that we can get the other witnesses here.
August 7th at 10.
August 7th at 10.
Thank you, Your Honor.
Your Honor, does the court have anything later than August 7th?
You want something later?
My client's asking if there's anything later. My client specifically himself asking if there's anything later than August 7th.
Are you busy on August 7th, sir? So why are you asking for something later?
Just for health reasons.
I'm not following.
I got a lot of cysts in my head. And I was
Okay.
planning on getting it took care of.
Oh, so you're trying to get some medical treatment? Is that what you're saying?
I'm trying to get it took care of.
Okay. Have you already had a kite to get some treatment, or is
It's
something
already
scheduled?
in progress, talk to them.
So you think they're gonna do that in
I don't know exactly.
August? Okay,
But I'm hoping this around that time, it's a slow process.
okay, here's the
If you
thing.
look in my head, I got a lot of like cysts in my head. I come up there and
I don't want to see them. I'll take your word for it, sir. Okay, so August 7th might be too soon because you're hoping to get some medical treatment.
I mean, it could be in August.
Just not the 7th.
Yeah, I was hoping a little later than that. If not, then I'll
August
go.
15th
That's fine.
And 9:30.
at 9:30. August 15th at 9:30.
Thank you.
No problem. Okay, any additional matters for the record?
Nothing on behalf of the people, Your Honor.
It's just that if at that time, Your Honor, the people have not produced these two witnesses to make the case, we're obviously going to move a motion for dismissal of them. So,
Absolutely.
thank you very much, Your Honor. Appreciate it.
Thank you. Okay, let's see. We did that one already, okay. I've not seen Miss Wanji. Do we know where she ran off to? I saw her earlier, but I didn't see her in the courtroom. Because Mr. Nagel is waiting on her.
Your Honor, I did hear from, oh, sorry, excuse me.
Was Yaki downstairs?
Yeah.
You said something, Mr. Nagel?
I apologize, Your Honor. I did hear from Miss Wanji. It sounds like she is in another matter with Judge Flores right now. I have reached out to her about this case. It sounds like she's coming right over as soon as she's available.
I thought Judge Flores was on PCCs.
Has been warned.
I'm only reporting what I've heard.
The PCCs couldn't take that long. How are you into the PCCs? Are they on the record over there? It's quiet. Sounds quiet. Let me go see.
Rise.
Not today. I'm struggling. Can you tell? We can go to the office here. I'll always make time for it.
There was no judge on the bench.
All rise.
They were just chilling.
There was no judge on the bench. Be seated. Okay. Are we running Yaki, or do we need to, we haven't brought up for this purpose?
We are waiving you.
Okay, we'll bring up Yaki. Mr. Abbott was covering for Etheridge on Walker.
They're out there talking.
Oh, okay, sounds good. What are we doing with dropping? Have you seen is dropping here?
I do not know where he is, Your Honor. I spoke with him yesterday. This is actually quite
Jarring.
jarring. Yes, that is the correct word. I do not know what is going on. I'd ask the court.
I can see it on your face.
I'd ask the court to give us a little more time. I have my paralegal. She has been reaching out to him to try to figure out. And like I said, I spoke with him yesterday. He knows about today. He's never guessed before. So what's going on?
Same, Aaron, same.
Okay, I'm sorry.
I just said same.
Sounds good.
All right, thank you.
Okay, they're bringing up Yaki on the record in the matter of the state of Michigan versus Jaquane Walker, 25-01309, appearance, please.
Your Honor, Haley Fortuny Bill on behalf of the people.
Good morning, Your Honor. Attorney John Abbott with the Ingham County Public Defender's Office representing Mr. Walker. He's present in the courtroom with me.
Mr. Walker has a preliminary examination on a police officer assault. Are we writing an exam today?
We are, Your Honor.
People are prepared to run the exam.
We're sure.
You offered, you can go discuss it with them.
Sounds like we may have a deal. Excuse me, Your Honor.
Thank you. Is he?
I think it's the best offer I've ever been. You want to run this exam?
I mean, I know they don't really make kids like they used to, but. It's good. On the record in the matter of the state of Michigan versus Gary Yaki, 25-016679, appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
Morning, I'm gonna get you one from the public defender office on behalf of Mr. Young.
Yaki, was scheduled to have a preliminary examination today on 3 counts of child abuse and 2 counts of computers. And how are we proceeding at this time? I'm sorry, it is child sexually abusive material, aggravated 3 counts. Are
Yes,
we
Your Honor.
having an examination?
Thank you, Your Honor. It's my understanding that the defense is choosing to waive their right to hold a preliminary exam. The people will also unconditionally waive their right to the preliminary exam. There's no offer to state for the record at this time. However, negotiations will continue once this case reaches the circuit court.
That's correct, Your Honor. I have discussed with my client and it is his wish to waive the preliminary exam at this time.
I'm just trying to understand how we ended up with this case. The search warrant was 253, at least that's what it says. 3708 Randall Street. Is that in there? 708 Randall, R8 and Randall Street. Is gonna be no fun down with that?
No, not him.
Down with that. That's what it's next to.
And the trip call.
Yeah, it should be. It's like right on the border, I suppose. Okay, I just wanted to confirm that this was supposed to be in this jurisdiction because it appeared in the affidavit of probable cause that the search warrant was signed by 55th District Court. But I've reviewed the address and I guess it may be on the line. I don't know. Nonetheless, your client does wish to waive this preliminary examination.
Yes, Your Honor.
Mr. Yaki, you do understand that you have the right to have a preliminary examination because you're being charged with multiple felony counts. You understand that? They understand the purpose of the preliminary examination? I'm sorry?
I'm not sure.
Okay, so the purpose of the preliminary examination is because you have the right to require that before this case can proceed, that the prosecutor first put forth enough evidence to show that they even have sufficient probable cause that these alleged crimes took place. And then sufficient probable cause that you were the person who committed these alleged crimes. You understand that? Okay, so if you waive that examination, no evidence will be no evidence will be put forth at the district court level to establish whether or not there's sufficient probable cause. The case will be sent to the circuit court for you to proceed to possibly trial without that hearing. You understand that? And that's what you want to do? Well, you're asking her if that's what you want to do. I'm asking you if that's what you want to do. She can't waive that right.
The waiver?
Yes.
Yes.
Okay, and no one's forcing you to waive your right, correct? And no one's promising you that they'll do anything for you if you waive those rights, correct? You're waiving it freely and voluntarily. Okay, I find your waiver to be freely and voluntarily made. The matter will be bound over to the circuit court for a bind over date of July 9th. That's not a date, sir, that you will need to appear in court. That is the date the circuit court receives the file from this court, okay? Your next court date will be a pretrial and circuit court, and your attorney will be made aware of that. Counsel, can you approach so that you all can sign this? Prosecution as well. No worries, I got it.
This is just.
Hard for week I've been having.
I get it.
Sorry, Mom. Yeah.
Oh, yes, thank you. Okay. Mr. Nagle, I did have your colleague sign on your behalf. The matter is bound over. Bond in this matter is 50,000 cash surety. That will continue.
Then I would like to request bond.
I'm sorry, we're on the record. So everything you're saying she's got to put in the record while you're talking over me. Yes.
And my client has some serious health issues. He has received started, and he has to take care of his medication. He suffers from diabetes. He also had some other issues regarding his health and coronary heart disease. So these are serious health issues that are not being taken care of at the jail at this time. We would respectfully ask the court to allow him to go home, even if he has to be a house arrest, because these issues are very serious. The conditions can be put in place to safeguard the community, including not being able to use a computer, not be around children, those kind of stuff. I think that if those conditions were put in place and later, that would be able to preserve the community. But I do believe also that my client has the right to take care of his health, and that's not been addressed at the court. So we would respectfully ask the court for medical reasons by looking to go home to take care of those.
How is he taking care of his health at home? I'm confused.
To be able to go to his medical appointments.
Why is it something that can't be treated while he's in the custody?
He has to see the cardiologist.
He has to see what?
A cardiologist. He has a heart doctor. He has to do some exams regarding his the stent that he had on his heart. He had a heart attack in 2016, and since that time he's having some heart issues.
Since 2016?
Yes.
Okay, so he has current appointments already that he was supposed to attend to?
Yes, sir. He has. The jail doctor wants to refer him to his cardiologist.
Mr. Nagle.
Thank you, Your Honor. Just with respect to the bond as it currently stands, the magistrate the magistrate or judge, whoever arraigned him, saw fit to set the bond as is, and it's worth pointing out too that this is charged as a habitual second offense. The defendant having previously been convicted of the same offense, child sexually abusive material possession, in 2005. So the people just have concern regarding the public safety. Certainly each time somebody downloads and possesses something, re-victimizes the victims in these matters. So we just ask that the bond stay as is. If in the court's discretion finds that it is appropriate to change the bond conditions, then the people would agree with the recommendation for house arrest. But other than that, Your Honor, we would just ask that the bond continue as is.
If I may, the previous conviction was in 2005. And
The previous conviction you said was in 2005?
And since that time, my client hasn't been in trouble and he's not been flight risk.
Let's see, what we have here. Okay, I'm just reviewing the file, because I do believe that he was arraigned by Magistrate Milner, who set a bond in place, $50,000 cash surety, with GPS tether, that he's not to frequent any areas where children are found. That includes playgrounds and schools, etc., and no use of computers or other devices to access the internet. The defendant has a complaint here. It has 6 counts. It is charged as an habitual offender, second offense notice. The first 3 counts being child sexually abusive material aggravated possession, and count 4, 5, and 6 being computers using to commit a crime. All felony charges. The defendant is facing 1 1/2 time the maximum penalty. I think the nature of the details are troubling, to say the least. I had a bond recommendation attached to the file, and it says that the people respectfully requested a high bond, that the defendant had a prior conviction for the possession of child sexually abusive material. Defendant has knowledge of basis and content. Defendant has knowledge basis content. I don't know if this is written right. Defendant has knowledge of basis and content child sexually abusive material based on his past experience. Every download or sharing of sexually assaultive, criminal sexually assaultive material images re-victimizes the child victims in these images. It says the continued possession of this material by the defendant presents a risk to the community. People request a cash bond consistent with the risk and GPS tether to secure his release of custody. So the court was aware of his prior conviction, which I think is for the same exact thing he's charged with now. So I recognize your statement that he's not, it's for child sexually abusive material in 2005. I recognize that the defendant has not had any convictions since that time. I don't know that your statement, though, that he's not been in any trouble is quite accurate, because I don't know what he was doing in between those times. I just know that he's not been before the court on the similar charges until now. So although there was a 20-year span, unfortunately, we now have a 6-count complaint pending, and one with 3 of those counts being the exact thing he is or was convicted of in 2005. Also, there's allegations of material that was recovered from your client's home, very disturbing material, including images of fully nude toddlers in positions that are very reprehensible. And so I won't even get into the details of that. I think that there's a grave risk to the safety of the community, and I think that the bond was set appropriately. I understand that Mr. Yaki has some health concerns. I even understand that he may need to be referred to see his own cardiologist, if that's a specialist that the doctor wants him to see. But the jail has the ability to get those appointments scheduled for him so he can get that. He does not need to be released on house arrest for us to do that. The other thing is, it's not actually, this is not a position where it's easy for us to monitor what he's doing in his house. And these are crimes that are alleged to be taking place by use of an electronic device. GPS tether does not help us see what someone's doing inside their house as it relates to an electronic device. He could get access to a phone, he could get access to an iPad, he could have another computer, all kinds of things, and we would not know. And so in order to ensure the safety of the community and the public, I think that the bond is appropriately set. It doesn't prohibit him from posting a bond. There was a bond set. He would just need to post that bond. Until that bond is posted, he'll have to kite to get the attention or treatment that he needs through the regular course of business at the jail. Bond as set will continue. Any additional matters for today's record?
Not for the people. Thank you very much, Your Honor.
Nothing for the defense.
You're all set.
Thank you, Your Honor. Have a good rest of your day and a good weekend.
Thank you. Is Mr. Lee step out or Mr. Inspector?
We're back here.
Okay, and then, let's see, we're going to, do we need to bring someone out? We might. Because I'm going to do, Mr. Starks was waiting for Milner, correct?
Correct, Your Honor.
We can bring up Milner.
Milner is going to be a request for adjournment.
For who?
Milner is going to be a request for adjournment.
I thought we were running Milner.
My understanding, Your Honor, that the people don't have all their necessary witnesses here, but they do have some of their officers. They can start the exam. If Your Honor would prefer us to start and then have to come back, that's my understanding.
And there's like 6 counts. I asked were we running, I thought we were running that one. Now, otherwise I would have called that one a long time ago.
I apologize for misunderstanding, Your Honor. There is one officer here. The other officer that we need to complete this exam is in a mandatory training today. He did let me know about it ahead of time. So we're gonna ask for it.
Okay, we'll have Milner, I did tell him to bring Milner up. Okay, and then I think we did Walker.
Thank you, Your Honor.
We did Yaki. Dropping, we don't know where dropping is.
Yes, Your Honor, that's actually gonna be upon speaking with the witnesses on this case. The people can't satisfy their burden. They're gonna ask for dismissal. Ours is.
Oh, yes, and he's going to go talk to, he's with Mr. Abbott, though, correct?
Yeah.
And then Shelton is a plea.
So we'll do you're doing a nollie on.
That is correct, Your
Dropping.
Honor.
Can I get a copy of that? I did get in contact with my
Oh,
client.
good.
But yeah, so he's at least okay, but if I could get a copy of that, I appreciate it. And then Mr.
We're gonna print the nollie right now.
What's your P number, Ross?
84591.
He knows it.
I've known it for like a month.
Exactly. It's been 30 days.
Gotta get it
Yeah.
tattooed
He's used to remembering it now.
Yeah,
on
I
your
know.
wrist.
I need to get my bar card.
P8 what?
84591.
See? So you'll still be in the 8s.
Maybe.
No,
And then
I don't know. I don't know what's going on with Michigan, why it's taking so long for your stuff.
Maybe somebody stole my identity and committed a bunch of felonies in California or something.
Is that where you're waiting for California?
Yeah. Yeah, I know.
Okay, let's see. Are we ready on Shelton? Back on the record for Katira Shelton. And I believe that you were going over her rights with her. Is that what it was?
That is correct, Your Honor. We do have a completed advice of rights that the court would like me to approach.
Yes, please.
Yes.
Thank you. Thank you.
Yes, Your Honor, the plea sheet is directly.
Okay. Okay, so I have sheet again, the offer is to amend to a attempted resisting obstruction officer, and the people will dismiss the remaining, correct?
That is correct, Your Honor.
You want to accept that, ma'am?
Yes.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Okay. Have an advice of rights and the information sheet. Is that your signature?
Yes.
And you went over these rights?
Yes.
Do you have any questions about any of these rights?
No, ma'am.
You're willing to give all of these rights up today? So that means that your right to be presumed innocent until proven guilty will be waived. Your right to proceed to trial, a jury trial, and have the prosecutor first prove each element of the charges being brought against you beyond a reasonable doubt will be waived. You also waive your right to remain silent at any trial and not have silence be used against you. Your right to see, hear, or question any witness that's called to testify against you, and your right to subpoena witnesses to testify on your behalf. You understand each of those rights that you would give up? Is anyone threatening you to get you to waive these rights and enter a guilty plea?
No.
Has there been any promises extended to you if you give up these rights?
No.
Are you currently on probation or on parole?
No.
You understand that by pleading guilty, it could result in a conviction that you may need to report to a current employer.
Yes.
You also could have to report this conviction on a future job application, or it could have impact on where you could travel or get immigration status. You understand that?
Yes.
As to the amended charge of attempted resisting obstructing, how do you plead? Guilty. Is that because you believe you're guilty?
Yes.
Factual basis.
Shelton, on or about June 8th, 2025, were you in the area of 5627 South King Boulevard in Lansing, Michigan?
Yes.
And that's in the county of Finley, correct?
Yes.
And at that time, you encountered police officers
Yes.
and they attempted to arrest you,
Yes.
and you resisted allowing them to put the handcuffs on,
Yes.
and you resisted being put into the squad car, correct?
Yes.
Thank you. No further questions.
Any questions for the prosecution?
People are satisfied, Your Honor.
Of course, satisfied with the factual basis, I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. This matter is scheduled for sentencing on August 22nd. You need to meet with probation. When you leave here today, you'll go down to the 5th floor, you'll check in with them. They'll get you scheduled and set up for a pre-sentence interview, which will be scheduled at another time. So you need to report for that interview as well, okay? They'll also advise the court as to your eligibility for sentencing under HYTA. You have any questions? Okay. Are you employed, ma'am? Are you employed?
Yes, I am.
Okay, where?
It's called Ring Meadow.
What's that?
It's a factory.
What do you do there?
I paint.
Okay, I was gonna say you look very athletic. That's
I
right.
used to be.
Okay, very good. Okay, so we'll get you down, have a seat, we'll get you down as soon as I can get a court officer to escort you to probation and checking with them, okay? And that's Milner? That,
Yes.
and Mr. Abbott, you're ready with Walker?
Yes, we're gonna run a preliminary exam, Your Honor. I think Ms. Wine is hoping she'll get her waiver done before I do that.
And I have a plea for a misdemeanor for Mr. Robbie Smith as well.
Ms. Wanji has Ms. Wanji has two more cases. Which waiver are you trying to do, Ms. Wanji?
Both your no. Edwards and Sterling.
Everybody, all your people are waiving.
Yes, sir.
Okay. Okay, on the record, in the matter of the state of Michigan versus Charles Milner, 25-01676, appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Good morning, Your Honor. Jacob Starks, the fourth Assistant Public Defender, here on behalf of Mr. Milner. Mr. Milner is present at council table. He's standing to my right.
Okay, today was the date scheduled for a preliminary examination on carrying concealed weapons, 2 counts, possession by prohibited persons, 2 counts, and then 2 counts. Only firearm. How are we proceeding?
Your Honor, at this time, the people would request an adjournment. The people do have one witness here. So we would be prepared to elicit testimony from that witness. However, one of our officers is in a mandatory training today. They did let me know ahead of time. I have been in contact with them, so we would ask for an adjournment so that we can get that officer here and do the exam all at once.
Which officer is here?
The officer that is here is Officer Wilson.
Harshman is not here.
That is correct, Your Honor.
Officer Wilson, not
Off-
Williams.
I may have written that wrong
Okay.
on my notes.
I have a Sergeant Williams on the paperwork.
So that is incredibly possible that I wrote down. Let me confirm.
It could be a Wilson, he's just not listed on the affidavit, I don't know. Okay,
That's also possible.
Mr. Starks.
Thank you, Your Honor. Mr. Milner would object to any request for an adjournment. Mr. Milner would request a dismissal if people are unable to proceed as an officer of the court, Your Honor. Of course, the prosecutor is free to ask for an adjournment, Your Honor, could decide this would cause, but I just want to make it very clear that Mr. Milner is not waiving anything in terms of his timelines, and we request a dismissal if people are unable to proceed. Thank you.
Your Honor, the people would just like to clarify that it is Sergeant Scott Williams who is present today and that I wrote down the wrong name on my personal notes.
What's the red name? That's what I thought. Okay, the officers in mandatory training, that's outside of the prosecution's control. The officer didn't just blow off court, so I'm not dismissing it. So the motion is denied. There's good cause to adjourn, and we'll reset this for a new date. August 7th at 9:30.
Thank you, Your Honor.
Thank you. Any additional matters for the record?
Nothing on behalf of the people, Your Honor.
No, Your Honor. Thank you.
Thank you. You're all set. And then we need to bring up someone for Miss Wanji. We'll do Juanita Edwards. Miss Schroeder, are we running Smith?
No, that's actually gonna be a plea, Your Honor.
Okay.
He is in custody as well.
I know I saw Mr. Goodrich looking here. Or did I make that up? Okay. Maybe it was, I saw him over there. Maybe that's what it was. Okay, Milner is done. We are running Walker. And I don't know what we're doing with Goodrich, but right now Walker's the only one that's running?
Goodrich, or sorry, not Goodrich. Trent is going to be a request for adjournment from the people.
Oh, if Mr. Goodrich is ready, we can put it on the record. It's only two judges here, so I don't know how everybody could be on the record over there at the same time. And they were supposed to be doing sign this really quick. Okay, on the record in the matter of the state of Michigan versus Juanita Edwards, 25-01684, appearance, please.
And this is the, Edwards, this is, Sterling. Time Sterling.
Sorry. Well, that's not good either.
She's over at, she's not here, she's over on, Kalamazoo. She's over
Well,
on
first, they said that they told him that this was Miss Edwards, and now I find out Miss Edwards is not here.
No,
So
she's
that's,
over in Kalamazoo. I
got
rode
it.
with her.
She's got another, you said who's with?
I rode with her over here.
She's got another court date somewhere?
Yeah, she's over in Kalamazoo right now.
Makes sense. But the jail needs to know who is here. Okay, state of Michigan versus Tammy Sterling, 5-01705, appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Good morning, Your Honor. I get you one chief from the public defender office on behalf of Mr. Daniel Sterling, who's not a county.
Okay, let's see. There was an offer that was exhibited at probable cause conference. It was scheduled for exam today in possession by a prohibited person. How are we proceeding?
Your Honor, the people are prepared to unconditionally waive the preliminary examination. I believe defense is going to do the same.
That's quite minor. The negotiation are going to continue very soon.
What counsel, if you can approach, please. Sure. One name. Yeah. Oh, geez.
I should go down and ask for Tammy Sterling.
See what happens. Okay, let's see, Ms. Sterling, you understand that you have the right to have a preliminary examination on this felony file? You understand that?
Yes.
You understand the purpose of the preliminary exam? You have the right to have the prosecutor establish at the district court level that they have sufficient probable cause that the felony alleged was committed, and then probable cause sufficient to charge you with the crime. You understand that? You want to unconditionally waive your exam today?
Yes, I do.
Is anyone threatening you to do that? Has there been any promises extended to you if you waive your exam? Your bind over date is going to be July 9th. That's the date the circuit court receives the file from the district court, not a court date for you, okay? Your next court date will be a pre-trial and circuit court. Your attorney will be made aware of that date, okay? You have any questions at this time? Bond was set at 3,500, 10%. Any additional matters for the record?
Nothing on behalf of the people, Your Honor.
Nothing for the defense.
Thank you. Do we have anything? I didn't, she has open cases, but I don't see anything scheduled for today. Maybe let's ask them what they did with our, yes, with our other person. I don't understand.
She's not here. Do you want to? Yes.
Yes, we can, if she's not there, you can bring up Smith. Oh, Mr. Goodrich. Mr. Goodrich, you have Jennifer Trent.
Yes.
Are we running an exam?
They don't have witnesses.
Oh, okay. On the record in the matter of the state of Michigan versus Jennifer Trent, 15-01991, appearance please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Attorney Luke Goodrich from the Public Defender's Office, representing Trent, standing to my right.
Okay, today was the date scheduled for a preliminary examination. Larceny in the building from 2015. And so we do not have the necessary witness here.
That is correct, Your Honor. I have been in contact with her. She is willing to participate. The reason she could not be here today is because she had a foot surgery. She did send me medical documentation to prove that she did have surgery on her foot, and she does live in the Upper Peninsula, so she would have to drive quite a long way, which she's unable to do at this time. But I have been in contact with her as soon as this morning, or as recent as this morning.
Your Honor, may we address the issue in that?
You may.
Thank you, Your Honor. Your Honor, at this time, the defense is moving to dismiss this matter. This is a case that's, as the court is aware, is 10 years old. It's essentially a landlord-tenant dispute from 10 years ago that somehow ended up in a criminal situation. I don't know how that became. Last week, Ms. Trent, well, first of all, Ms. Trent lives in Florida. She flew up to get her, she has been trying to get herself licensed to do chiropractic work. This old warrant popped up. She flew to Michigan to get herself arraigned in this case. She has been in constant contact with me throughout. Last week, she was willing to waive her 21 days if we needed a new date to make sure the date worked for everyone. I double checked with the court, the prosecutor. They assured me that today would work as a date. So she bought airline tickets. She flew up from Florida. She's unable to work at this time, has very limited income, and is basically using every dollar to fly up here from Florida to address this matter. The prosecutor had been in contact with this woman prior to last week, prior to that time when she could have rescheduled her flight, and apparently never gave them the information at that time and waited until the last minute to drop this. As a result, Your Honor, we've also, like I said, discovered information we'll get into, which I believe that these allegations are false to begin with. So we were asking that this matter be dismissed at this time based on their failure to appear for this preliminary exam.
Okay, counsel, is it true that there was a communication for her to self-surrender and to fly here for this purpose, and she was told that this date would work?
Your Honor, I don't recall. I'm not saying that didn't happen. Someone was filling in for me for this case last week, so it is very like I totally believe Mr. Goodrich that occurred.
I did check with Ms. Nash regarding the report to make sure everything
So there was a scheduled exam date. It's not, Nash didn't set the exam date. I thought you were saying that she coordinated with the self-surrender.
Well, no, she turned herself in on her own a couple weeks
Oh,
back.
well,
to
then
get this
nobody.
set. But then last week for the probable cause conference,
Okay.
I'm saying I spoke with Ms. Kachukis, who was handling the matter last week. And we just made sure that today's date was going to work before she bought airline tickets. And we were
Well,
assured that she would.
unfortunately, First of all, this case was pending for 10 years. And that's not because of anything the prosecution failed to do. The case was pending. Your client was in warrant status. She could have turned herself in a long time ago on this.
Well, yeah, and I don't believe she was aware of it until she was, this case arose out of her moving out of a residence and essentially moving at that time.
But it was.
It was never notified. She was never notified of this case.
This was signed in 2015.
Right, she was no longer
So
living in
since-
the state of Michigan by the time that they issued charges in this case.
Okay, so she obviously must not have had her criminal history ran for any purpose, no jobs, no travel outside the state or the country, no licensing in the new state that she was living in.
She had been doing mostly schooling and stuff, and she recently completed that, and it came up for licensing issues.
And so she applied to school and they didn't know she had a pending felony.
I don't know what the school checks exactly.
Every school I went to checked to see if you got a pending felony. I just believe that she had reason to know that there was a felony proceeding against her. And a lot of times when people live out the state, then they let things fall through the cracks. I don't know why it sat for 10 years. But because the prosecution is now in contact with the alleged complaining witness, that witness now is ready to proceed with the case. And so if the case even were to be dismissed, and I don't even know what the statute of limitation is on this larceny in a building, because it's 10 years at this point. If they still had statutory time, I'm sure they would reissue, which would mean your client would have to fly back here to be rearranged. Your client also has the option of waiving her in-court appearance for the preliminary examination. And that would also waive the requirement for the victim, the alleged victim, to have to come down from the UP, and we can do this 100% virtually.
Well,
But
Your
that's
Honor,
up to your client. Is it the state's or the prosecutor's position that they're going to reissue this?
Your Honor, I can't say for certain, but this victim is participating, so usually my office, yes, would move to the issue.
Your Honor, she was participating a week ago and apparently withheld that information, that major information that I'm not available the following week, last week, when they talked. So we don't know how truthful this information even is.
And you said she provided you evidence that she had foot surgery?
She did.
I want to see the evidence.
Okay, Your Honor.
That's a valid point. If she spoke to them before the probable cause conference, she should have advised them, I'm not available next week, though.
The documentation that I received the Wednesday of this week.
That's what you can approach.
You want to just, it's like,
Would it-
don't need to scroll.
Yeah,
or
you
do you
can
wanna scroll? Let me see, is there a name on here? Okay, yeah, up here. Is her name,
Okay.
date of birth and stuff.
Oh, she's having it today. Can you scroll back up? That's what it looks like.
Oh,
Looks
yeah.
looks like she's having it today.
Okay, yeah, that wasn't very clear in the email. But yes, you're right.
I don't know why she didn't, I don't know why she didn't share that.
Maybe it wasn't scheduled the last minute. I have no idea.
You know, I would find it hard to believe that a doctor's office scheduled something within a week.
I would agree that they probably did not schedule it within a week. And then also, maybe, and I don't know, I can only surmise, maybe she's thinking, well, I have court, I'll see if I can get my surgery scheduled. I don't really know. I don't know why that information wasn't fleshed out prior to that. All I know is that if they're gonna reissue it, it's not in the best interest for me to dismiss
And
it.
I don't know if they legally can issue this based on the statute of limitations. Like we have run years ago.
And the only information I have, because I'm how old the case is. And I'm even looking at the officers, which I don't even think work with the department anymore, but nonetheless, it's an allegation of larceny in a building, stealing a television set and or coffee maker, and or a reciprocating saw, and or queen size bedding. The motion is granted.
Your Honor, at this time, based on Ms. Trent's seeking out licenses, she has asked me to request that the fingerprints and arrest record be destroyed in this matter. Would the court be willing to sign an order to that effect?
Yes. Thank you. Okay, ma'am, we'll get you. It's got you 6 years. I know it can be 10 for this, for washing the building, like. They barely give you that for CSC, so, good luck to you, ma'am. We'll get you a copy of your paperwork in just a moment.
Thank you, Your Honor.
Furthermore, like. No.
Your Honor.
Thank you. Stop for her.
What?
That's not for her.
That I fought for that adjournment. I did.
Yeah, go ahead.
Right. Here.
Aaron, you vouch for me? I practically cited that adjournment. Okay. I did.
Who's that back there? Okay. That's your client.
He's right over there sitting
On
down.
the record in the matter of the state of Michigan versus Rodney Smith, 25-01683, appearance please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
And good morning, Your Honor, Assistant Public Defender Aaron Schroeder, on behalf of Mr. Rodney Smith, who is staying to my right. I'm gonna have him I can have him very quickly here, hopefully,
No problem.
jot down his signature on the advice of rights. He has reviewed them.
So there's no Edwards. Just over
Take a
there.
sign and then print your name below.
Sounds good.
and put your address.
Did we tell Ms. Wandy? She must.
Yeah.
Do you have witnesses here on that one? Or were we waiving? Is that what Edwards was doing?
So.
Oh, okay. So we can reset that via Polygon.
Got it?
If I may approach.
Yes, thank you. Okay, let's see here. Mr. Smith. So the offer of the people was for you to plead guilty to an attempted resist obstruct an officer and that they would dismiss the remaining counts. You understand that? You want to accept the offer? I mean, I don't know what that means. Is it a yes or no?
It was a little iffy situation, but it's seriously something that I can actually go ahead and work with.
We'll see. Raise your right hand. Your other right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Okay. I have an advice of rights of the information sheet. There's 2 pages and that's your signature?
Yes, ma'am.
Okay, and you went over these rights with your attorney, correct?
I did.
You understand all of these rights, sir?
I do.
So you know that you would have to give up all of these rights if you want, you put your hand down. You have to give up all of these rights if you wanted to accept the offer and plead guilty to the attempted resisting obstructing officer. You understand that?
Yes.
So as you stand there today, you are presumed to be innocent until proven guilty. You have the right to continue this to a jury trial and have the prosecution first prove each element of the charge being brought against you beyond a reasonable doubt before you are considered to be guilty. You understand that?
I do.
You have the right to remain silent at any trial and they can't use the silence against you, or you can waive your silence and testify if you'd like. You have the right to subpoena witnesses to trial that will testify on your behalf or present evidence at your trial that you think show a defense to the charge being brought against you. And you also have the right to see, hear, and question or cross-examine any other witnesses that they call to testify against you. You understand those rights? And all of those are the rights you'd have to give up today if you wanted to plead guilty. You understand that?
I do, Your Honor.
And that's what you want to do.
I do.
Anyone threatening you to get you to waive your rights?
No.
Any promises extended to you if you waive your rights?
No.
Are you currently on probation?
No, I'm not.
I'm assuming he must have requested for appointed counsel last week. I've just caught the note that he declined for appointed counsel, so he did request. Okay, okay, and no one making any promises to you to get you to plead guilty?
No, Your Honor.
Okay, and are you pleading guilty because you believe you're guilty?
Yes, Your Honor.
Okay, as to the attempted resist and obstruct an officer, how do you plead?
Guilty.
Factual basis.
Thank you, Your Honor. Mr. Smith, back on June 7th of 2025, so earlier this month, were you at or near an address of 120 West Michigan Avenue?
I was at the illegal residence, but
Oh, okay, just, were you at the police Lansing lockup? Were you at the Lansing lockup with the detention officers?
Yeah.
Okay, and if I were to tell you that Lansing LPD, Lansing Police Department lockup is located at 120 West Michigan Avenue in Lansing, Michigan, would you have any reason to doubt that?
no, I don't.
Okay, so you were at the Lansing LPD lockup at that time, correct?
Yes, I was.
Okay, and at that time, regardless of what led you to be there, you were there and the detention officers, they were trying to get you searched to book you in, correct?
Indeed, I was in custody and I was trying to prove my innocence.
Okay.
So that's why I actually had a jerk activity to leading me to the ground.
Okay, so what happened was is that you started pulling away from them when they were trying to search you?
I did, and I was
Okay.
proving myself to actually just really just.
Okay, Your Honor, I believe, and I'm sorry to cut you off, but I believe, Your Honor, we've made the factual basis for the attempt resisting obstructing. If the prosecutor of the court. has any questions.
No questions from the people.
Okay, so he was already in custody at LPD and they were trying to search you, is that what it was?
Yes, Your Honor, there was
Okay.
it had to do with the charge that's being
Got it.
dismissed.
I'm just trying to understand their lawful duties, okay?
If you don't
Yep.
mind.
Yep, no problem.
Yeah, I was just trying to actually just tell them that I was simply innocent for the crime activity that was occurring around that point, around that.
The one that they were investigating,
Yeah,
okay.
the one that they were, supposed to actually really look into a little bit harder than to actually just really walk outside and actually really obtain me and actually just take me into custody for no reason without questioning and actually just adjusting himself to taking my innocence and actually just using me for whatever reasonings they actually really wanted to go ahead and actually just take me for. So I was looking at the situation differently, and I actually didn't understand if I actually really should have actually just, you know, felt different about the situation. So I didn't really want to, you know, kind of listen immediate without actually having a good reasoning behind it. So I kind of actually just didn't understand it. I didn't, you know, forcefully pull myself away, but I was in the means of, you know, verbally telling them that I just don't want to actually just really look at, like, I don't want to be arrested because I didn't do anything. Please investigate it. And then I got pushed against the wall and then slammed to the ground and detained differently in the wrong way.
Okay, so you were already in custody?
I was in custody, yeah, beforehand, and I guess.
And you were at lockup or in the building at the jail?
Well, they brought me in from the
From the location of the other
yeah.
alleged incident, and they need to search you so that you can go into lockup. Is that what's going
yeah.
on? And you're saying whatever you're saying because you want them to investigate the other offense, which in your idea more thoroughly.
Indeed.
Okay, and so are you just using words or did you pull back from them?
Well, I was verbally using words, and I actually really, my reaction was something different because my hands were already
Yeah, because you're cuffed, right?
Yeah, I was already
Can
cuffed.
you demonstrate what you did?
Well, I was sitting differently. I don't think it was these cuffs.
It was not. Those are more belly chains.
I was handcuffed with my backside. And I actually just really didn't want to, you know, listen with the cooperation because I was, you know, detained as a individual, being a civilized citizen, growing up here even. And I was looking at my record actually, you know, build with all of this LPD, and it's always me being, you know, something of the innocence. And I can't, you know, fight against, you know, local police officers who are actually really carrying weaponry that actually sit different. So I actually think I think he actually took my hands out of the cuffs, I believe. I'm not sure about that.
Okay, maybe you were still cuffed, maybe you weren't.
Yeah, but I actually.
How did you attempt to resist?
I wasn't really in a resistible activity. I think it was more of a verbal activity, and I was just like, and they actually, you know, kind of freaked out on me, and actually just kind of took me and actually just pulled me to the ground and actually, you know, kind of actually detained me in a.
So you were just using words and they pulled you to the ground?
More than likely, and I was it was in a horrible manner, and I actually didn't understand, you know, why the reasoning was in the first place, that I got, you know, taken immediately already, forcefully without question, and I was asking them to investigate. And like,
you have witnesses here?
Sorry, Your Honor. I do. I did have police officers. I would have to go check the room and make sure they're still there. I did tell them that this was likely to be a plea, but to hang tight. So I gotta go check. I guess I can't tell you for sure if they're in that room.
Because I can't accept the plea.
it was assault immediately on my behalf.
I get it. I don't have a factual basis.
Okay, Your Honor.
So, how many witnesses do you have for Walker?
I have 2 present, but I
Let me guess, some people are at mandatory training?
No.
Oh.
No, I got them all this time, Your Honor. And I did have all the witnesses for this case too. I would have to make sure that they're still here.
Got it.
If they listen to me, they should.
It's not your fault. You can't handcuff them here, so. We can go see if you want to.
Cool. Thank you, Your Honor.
You can have a seat, sir.
Can we address what?
Oh, yeah, my understanding is, I thought you had left. Yeah, my understanding is that she was not brought over. She had another court date. But of course, I got that from your other client. And so she's not here one way or the other, because I did send the court officer back down to look. So I just had to find good cause and reset it. And she's doing a waiver, so I said it could be set by Polycom. Because we don't know. We did try to look it up. We didn't see anything in the system that says she had another court date, but maybe she was a witness. I don't know.
The officers that we subpoenaed either.
Okay, back on the record for Smith. Are we ready to proceed?
Your Honor, the people are unable to proceed. We do not have our officers here.
Based on that, Your Honor, then I'd be asking for dismissal of this case. Thank you.
Motion to dismiss is granted. We'll get you a copy of the dismissal.
Thank you, Your Honor.
You should be released. I'll have to take it back to ICJ first to get the book out. You got a way to get that home? Okay, okay. Well, you take care of yourself. You went a long step.
Thank you.
Take care of yourself. You're welcome.
Thank you, Your Honor.
The Walker exam will only be one witness.
Okay,
Thank you, Your Honor.
thank you.
They were both here, but I only need the one. That one really did.
Last case. Listen, you're doing good. You're doing better than that. I don't know how yesterday, like.
Right.
What
That
blew
was
up.
that.
Oh, that was a little one day. I was like, you gotta wrap this up. On the record in the matter of the state of Michigan versus Jaquan, or Jaquan, is it? Jaquan Walker, 25-01309, appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Good morning, Your Honor. Attorney John Abbott with the Public Defender's Office representing Mr. Walker. He's standing here next.
Okay, Mr. Walker was scheduled for a preliminary examination today. I'm looking at the notes here. It looks like the offer previously was an open alcohol container. No, open container in vehicle, 90 days with HIDA. That was the previous offer, but there was a different offer today, correct?
It was, Your Honor.
Oh, which was?
Any misdemeanor we could think of with HRPA, and I thought of trespassing.
Okay,
Rejected that offer and we were ready to proceed with the preliminary.
okay, that's what you want to do, sir? So yes, okay, you can call your witnesses.
Okay, Your Honor. The people would call Damon over to the stand.
I need to make sure. Solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
Thank you. State your first and last name and spell both.
Damon Pulver, DAMON PULVER.
You can proceed, counsel.
Mr. Tolbert, can you tell me what you do for a living?
I am currently a police officer.
And where are you a police officer?
I'm a police officer for the city of Lansing.
Okay, and how long have you been a police officer for the city of Lansing?
I have been a police officer for about 5 years.
Okay. And all of that time was with Lansing?
Yes, ma'am.
Okay. And officer, were you working on the date of May 4th, 2025?
Yes, ma'am.
Did you come into contact at all with, I'm sorry, is it Jaquan? Jaquan, okay, it's important that I get that right on the record. Jaquan Walker, or did you come into contact with
Mr. Walker.
Mr. Walker?
Yes, ma'am, I did.
Thank you. And can you tell me a bit about that interaction?
Yes, so on that night, I was working in a road patrol aspect, wearing my full departmental uniform, driving a full departmental car. And I was dispatched out to a fight call at Sir Pizza, which is located near the intersection of Turner and Cesar Chavez.
Okay.
When we arrived on scene, other officers were there before me, but the fight had broken up. But the staff there had closed down the bar and was getting concerned about crowds starting to gather in a parking lot across the street, which is associated with a park in the area.
Do you know the name of that park, by chance?
So it's the Fish Ladder Park. It kind of goes by a couple of different names, but Frankie Fish Ladder Park.
Okay, do you know the address?
Off the top of my head, I don't recall.
That's okay. Fish Ladder Park, is that in the city of Lansing?
That is.
And is that in the state of Michigan, county of Ingham?
It's in Ingham County, state of Michigan.
Thank you. Continue.
So I started patrolling the parking lot, looking for people that were just hanging around the parking lot, trying to avoid anything that was going on.
Did you see
And-
anybody in that parking lot?
Yes, I did.
And so who did you see in that parking
I
lot?
saw Mr. Walker in the parking
Do you see Mr. Walker here in the courtroom today?
I do.
Can you describe an article of clothing that he's wearing for the court?
Black Ace Ventura t-shirt.
Thank you, Your Honor. At this time, the people would request that the record reflect that Officer Pulver has identified the defendant as Mr. Walker.
Any objections?
No objection to identification.
Identification's noted.
Thank you. So how did your interaction with Mr. Walker proceed?
Yeah, so when I went into the parking lot, a big area of concern was that, again, people were in this parking lot, and at that time, it was around 1 o'clock, later than 1 o'clock at night, which is far past park hours being closed.
When you say 1 o'clock at night, you mean 1 a.m.?
Yes, yeah,
Awesome.
1 a.m., sorry.
No, that's okay. Just want to clarify for the record.
So 1 o'clock in the morning, I apologize. Which in the city of Lansing, there is a local ordinance that prohibits people and vehicles from being in parks and parking lots associated with those parks. So there was a civil infraction occurring in my presence, so I went up to the vehicle.
Objection, Your Honor. It's a legal conclusion.
Objection sustained.
You went up to the window and what occurred then?
So as I'm approaching the vehicle, I noticed that there was a sole occupant in the car that was in the front passenger seat. And I noticed what I would describe as a furtive movement reaching down towards the floorboard of that area. So as I went up to approach the car, I identified myself as a police officer. And
Were you wearing your uniform?
yes, I was.
Your fully marked LPD uniform?
Yes, ma'am.
Okay, and you were in a fully marked LPD police car at this time as well? Well,
Correct.
you exited the,
Yeah, the police car was a little ways away. but
okay,
It was in the area.
okay.
So as I walked up to the car, I again identified myself and, let the occupant know why I was stopping and talking to him, and requested their identification.
Okay, and how did Mr. Walker respond to that?
Mr. Walker refused to provide his identification. When I first made contact with him, I asked him to roll the window down, but the car was not on, so he opened up the door slightly. When I told him he was being detained, and that I needed his identification, he closed the door on me. I asked him several times to open up the car door again. He was not opening up the car door, and it just kind of led into an interaction where he was not responding to the commands I was asking for him to identify himself.
So how did you proceed?
So eventually, one of my partners was able to find an unlocked door from the vehicle and opened it up. And we began having further conversation with him that way, telling him that he needed to step out of the car and identify himself. Eventually, he did open up the car door more fully this time around, and I was able to see further into the car and noticed a open container of alcohol in the vehicle, which again was just a furtherance of more of a reason for contact and wanting to get him out of the car. So we asked him to step out of the car. He refused to do so, which eventually led to us having to put our hands on him to pull him out of the car, which he tensed up when I grabbed onto him and wasn't fully complying with my commands to step out of the car.
Okay, and were you wearing a body worn camera?
I was wearing a body worn camera.
And if I showed you that body worn camera footage today, would you recognize it?
I would be able to recognize it, yes.
Okay. Well, I have it. I have the Zoom room. Thank you, though. Your Honor, at this time, let the record reflect that I am showing defense counsel what it's not marked, but what is proposed as People's Exhibit 1.
Okay.
And this is, yeah, this is this officer's body worn camera footage.
So noted.
May I approach?
Yes.
Do you recognize this video, officer?
I do.
What is it?
That is my body worn camera video from that night.
Okay, and by that night, do you mean May 4th of 2025
Yes.
at approximately 1 a.m.?
Yes, ma'am.
Okay, Thank you. Your Honor, may I publish this exhibit to the court?
Yes, I'm giving you permission to share your screen. If you have to share sound, don't forget to do that.
Right. Okay, Your Honor, at this time, the people would move to have People's Exhibit 1 admitted into evidence and published to the court.
Objection.
I guess it's all at once, it makes more sense. Sorry, I didn't hit the share sound button, even though Your Honor reminded me. Okay, now we should be good.
Hey, what's going on, man? So we got
Nobody over here. I've been in this car this whole entire time since they've been in the party. No,
fair enough. So hold on, whoa. Hey, you're in a park after dark. I need you to identify yourself. So hold on. You are currently.
Why are you opening the door? So
Yeah, well, you ain't listening to it. Okay, listen. Hey, relax.
Bro, hey, what's your subject?
You gotta relax for a second. You gotta relax for a second.
He can't do
Hey,
that.
I got my bosses. My bosses are right here. My bosses are right
here.
here. Relax for a sec. Relax for a second, bro.
Okay, thank you. Bro, that is against.
So we got two things going on here, right? I need you to listen to me for a second. Okay? So two things.
Against the law.
No,
Y'all
I'll tell you.
violating the law. I hope y'all know that.
No,
I hope y'all know that.
Can you listen to me for a
'cause
second?
I did not talk to y'all.
I was trying to figure out if it'll let you mute your thing and because I didn't hear the feedback over there.
Maybe.
No, here's the deal. Here's the deal, man. Here's the deal.
I'm not none of that.
Here's the deal. You
I
are
don't wanna talk to
you are currently in a parking lot loitering.
Waiting on my friends.
Okay,
I'm
and then
not
on top of that,
anything.
and then
I was
on
over
top,
there.
hold on, listen.
I was over there at the party. I
And then on
left over
top of
here,
that,
and then
this
you all
parking
tried to
lot
talk
is associated with a park. It is a city lot,
You're
and
talking
you
to
are
everybody.
currently in
You're
a
talking-
park after dark, right?
You're talking
So
to
I
me,
need
but
you
you're
to
not talking to
identify
everybody
yourself.
else.
I need you to identify yourself.
No, I do not need.
I do this one car at a time, man. You're the one car that I stopped so far. I promise you I'm going to do it to everybody
Talk
else.
to everybody else.
I'm about to, but you're the first one.
The only one ain't here doing this, bro.
Everybody else is sitting in their car. I just got back to the car. Y'all, you know this. You just tried to talk to me 8 times. Bro.
So here's the deal. I need you to step out of the car, or else we're going to have to use force on you.
Why? For what? What have I done?
I'm telling you.
What have I done? Am I a suspect?
You're in a park after dark and you're loitering in a public
Bro,
lot.
I'm in a park. Hold on, bro. Let me take off my ski mask because it was cold outside. Hold on, bro. 'Cause y'all are tripping. I'm not gonna lie.
So at the end of the day,
not
man,
that
it
deep.
could
We're
just
making it a big
be,
deal.
it's just an identify, make sure you are who you are. Maybe
What do I have
we
to
write you
identify
a
myself
warning
for?
ticket for being in
Sir.
the park after dark,
Sir.
and that's it.
Okay.
Yeah.
All right, sir. What do I have to identify myself for?
And then there's also an open container of alcohol.
My car. What the?
Doesn't matter. You're next to it. I got 3 violations on you. Loitering, park after dark, and open container of alcohol. That's 3 violations.
Just go ahead and step out of the car, man. Step out, brother.
Hey, watch out. Y'all cannot do that at all. That is against the law.
Yeah, we
My
can.
life, that is against the
Step
law.
up. Just
You're
step up.
violating the
Step
law.
up.
You're violating
Step
the law.
up.
You're
Step up.
violating law, and you're. Hey, do not touch me. I'm getting out the car willingly, and do not touch me
Okay,
at all.
then
Do not
listen
touch
to
me.
us. Step out.
Do not let me walk over there.
No.
Walk.
You're gonna
Yes,
step
because
out
you
of the
guys
car
are
now.
crowding me. I feel uncomfortable.
Stand up right now.
You don't
I'm going to put my hands
understand
on you. Stand up right now and put my hands on you.
Stand up right now. You're putting. You're recording.
Absolutely.
Step
Yeah.
out of the car.
Step out of the car.
Watch out.
Step
I
out of
said
the
I'm
car.
getting out of the
No,
car.
okay, step up.
I'm getting out of the car willingly. Get. Bro,
Step
get
out.
away from me. Get away
Yeah.
from
Step out of the car.
Get away from, bro, I don't
Step
have
out.
enough space. I
That's
don't
a
have
lot
enough
of,
space.
that's a lot.
Whoa, watch out, watch out, watch out.
Step out.
Whoa.
Step out.
All right, first off, I'm too tall. First off,
Out of the car.
put your foot down, man. Let me, bro, let me. All right, bro, y'all doing too. I'm not forcing, bro. Watch out. Watch, bro, watch out. Y'all are bugging. I'm not, no, I'm not.
Stop
being
resisting.
detained.
Stop resisting.
What am I
You're
being
tensing
detained
up.
for?
You're tensing up.
Bro, watch out, bro. I'm not being detained for nothing, bro. Bro, I've been talking to y'all this whole time, bro. Watch out. I'm not, bro. Watch out. Hey, bro, somebody grab my cousin, bro. Bro, grab Tone. Bro, ask for Tone in the party right now. Ask for Tone. Bro, ask for Tone in the party right now. Ask for Tone.
Put him in the car once you get out of here.
No, what am I being detained for?
Right now, it's our no too.
Please.
Listen to our commands at all. We gave
I'm
you
not
no
listening to
pushback.
your commands, sir.
Stop
You asked
moving
me
your
what I
hands
was
like
doing in the
lock
parking lot. Did y'all not just ask me what
Did not
Dude, you need to stop. Bro, everybody else is gonna call you. That's not doing this to anybody else.
I don't see anybody else hanging out in the car.
You do not have my consent. I'm not under arrest. I'm being detained. Bro, watch out.
That one's open, isn't it?
Bro, where is my cousin at, bro? Watch out, bro. Get off of me, bro. Bro, watch out, bro. What is it? All right, bro. Bro, put my hoodie on, bro.
Don't.
No further questions for this witness, Your Honor.
Thank you. Good afternoon. Thank you for being here. All right, so this parking lot at the Breaking Fish Lair, the south end of the parking lot is abuts up to the park, right?
That's correct.
And the north end of the parking lot opens onto Cedar Chevet.
Yes.
Yeah. Turner Street.
Yes, sir.
And there's businesses open there. The Pizza Hut was open. The pizza.
At some points throughout the night, most of the businesses around there are closed, but the Sir Pizza around there was open up until around that.
Yeah, and then also a little bit to the east, the Unicorn. That might have been open still.
It's been closed for a minute.
You said Unicorn?
Is there a bar up there called the Unicorn?
There was, yeah, there was. It's not open anymore.
Not open anymore. All right, so anyway, and there was a lot of cars in the parking lot.
There were, yeah.
And they were probably customers of the pizza place. But we don't know.
Unknown. So.
But based on your analysis, every car in that lot was buying a lot.
Yeah.
If anybody was there, even though it was a city lot and there's businesses open on the street.
So since it's associated with a park, then yes.
By associated, you mean the south side of the parking lot, or what's the park?
The signage has the park in front of the parking lot before you enter into it, so I would consider it that, yes.
All right.
You said the signage has the park where, and then I didn't hear what you said.
I'm sorry. So there is a sign that says Brennicky Fish Ladder on the east side parking lot entrance. It's like a big sign that kind of.
Okay, it says called the Fish Ladder, and so the Fish Ladder is considered a park?
Yes.
Okay.
Right, but there was no evidence from his behavior, or from anything you observed, or any of the other officers observed, that he was actually in the park.
I didn't see him physically like in the grass of the park.
Right, he was in the car when he got there.
He was in the car in the parking lot, yes.
In the passenger seat?
In the passenger seat, correct.
Okay. And I heard somebody, I guess, what the videos. As far as that ordinance goes regarding the park, it's a civil infraction, isn't it?
That is correct.
Okay. And also, there was a couple of points in there where he said, let me get out, I'll go over there. Let me get out, I'll go over there. Do you remember him saying that?
I do remember him saying he was going to say.
And so he was willing to leave the park. If he had not wanted to leave the park, that would have been a misdemeanor, right?
That is correct.
Okay. So you thought he was guilty of the civil infraction of being in the parking lot after dark.
That, yes, that was one of the infractions.
And the other infraction was
Loitering in a public lot and then the open container.
loitering. How many seconds do you have to sit in your car before you're loitering, you know?
I wouldn't say that I know the seconds. From when I reviewed my police report, I remember observing the car for about 4 minutes in the parking lot.
Okay, so he might have been there for 4 or 5 minutes. Okay. And in your mind, that was loitering?
In my eyes, you know, sitting there not being there for an apparent reason, that would have been one of the reasons.
So waiting for the other guy to come out and get in the car and drive away wouldn't have been an apparent reason?
It could have. I mean, I don't.
Okay. So at this time, you mentioned there was lots of people leaving the pizza place and getting into cars.
My recollection.
And were they all being similarly ticketed for the civil infraction?
If I would have done the same thing with him, I would have moved on to the next car. So I would have done the same thing for everybody else in the parking lot.
So this one happens every night up there in all time?
Objection, Your Honor. Relevant.
Okay, you're right.
Justice System.
And there looked like there was lots of policemen there.
There were, yes.
Can you give me an estimate of how many officers have responded?
That were responded out there. I don't know entirely. I remember there being around about 5 or 6 specifically in this interaction.
So 5 or 6 guys helped pull him out of the car and put him on the ground?
We never put him on the ground.
Oh, no. Okay, so put him under arrest.
I don't specifically recall exactly how many, but it was
a group effort?
A group, I would say, yes.
And so he was charged with it. You know what he's charged with?
Yes, we charged him with resisting, obstructing, and open container.
Okay, making nothing for you.
What time is this again?
This was about 01:30 hours in the morning.
About 1:30 in the morning?
Yes, ma'am.
Okay. Did you ever determine if someone else was operating that motor vehicle?
Eventually, there was another individual that came out and said that the car was registered to him.
He came out of where?
I don't specifically remember where. I would imagine he came from Sir Pizza.
So I recognize that there's a fish ladder that is a park over there, but that city lot is not open for people to park in after a certain time?
So in times past, I've asked the city attorney about that parking lot itself, and they described it to me as a parking.
Can people park in the city lot after a certain time?
I don't see any posted signs that say otherwise, that say that there are or aren't.
So then does it say, no parking after a certain time?
I do not know. There's
So
not
then
any
it would
sign.
be open to the public to park there during that time, correct?
The way that I understand it, since it's associated with a park, then that would be a part of the city ordinance says the park and parking lots associated with.
But you made that determination, not, that's your interpretation?
So it's both my interpretation and also when I contacted the city attorney, they directed me and said it was a parking lot associated with the park. And then that on top of loitering could be used.
It's associated, but it's not only for the use of the park?
I would say it's not solely for the use of the.
I know, but I park there to go into the business that's connected around the back.
Right.
And so actually, that's where you park if you go to the business around the back. That's why the city has that there. You could pay it per meter there during a certain time, correct?
I would imagine so. I don't park there.
But you should, I would imagine, it be policing whether or not people are lawfully parked there, no?
Would you say like issuing citations and checking?
No,
like-
you're there to see if people can lawfully park there. So you should know if they have to pay a meter during a certain time, correct?
I would suppose so. I mean, to my understanding, the meters don't run after a certain hour. Those fall usually outside of my timeframes. I believe it's like 5 or 6 o'clock in the afternoon. My shift hours are strictly nighttime and fall outside of that.
Correct. Okay, so it would be city parking and a park that's connected to that city park.
I would say that'd be fair.
Okay, and so no signs posted, they say you can't park here after the park's closed.
All there being signs saying that it's restricted.
There, because there's other parks, and I'm trying to think of the park that's over off Oakland. There's a parking lot there, but there's no businesses there. It's just that parking lot. And there's a sign as you enter that tells you that you can't be there or park there after a certain time. So there's, I'm just trying to clarify, there's nothing similar at this parking lot.
Not one that I recall. I would say the vast majority of the parks in the city don't have that. Some do, absolutely, but I would say a good amount.
Correct. But you would agree that this is a unique location because this is where a lot of businesses and restaurants are.
I would agree that this is a unique location.
There's a location that has events there, right across the street on Turner, correct?
Yeah, there's another, there is another bar further up. I can't remember the name of it off the top of my head. But
Okay, and at 1:30, there are things open.
To my understanding, it would be Sir Pizza. Sir Pizza's typically the only ones open up late. I know that they're, to my understanding, the other bars aren't open as late, but.
So you originally believed that this might have been at most a civil infraction. What caused you to open his door?
So the first time or the second time, or just in general?
In general.
In general, okay. So the first time, when I asked him to roll his window down, he said that his window wasn't rolling down because the car wasn't on. So I can't recall if either I opened the door or he opened the door the first time around.
Okay, you can't recall? Could we refresh this recollection? Yeah.
I am.
Hey, what's going on, man? So we got
Nobody over here. I've been in this car this whole time since they've been in the party.
No, fair enough. So hold on. Whoa. Hey. You're in a park after dark. I need you to identify yourself.
Are we able to go back?
Hold on. You are currently. Yeah, well, so we got
You stop. Oh, wait. Keep pausing right there. When you said the first time, are you talking about this?
I'm talking about this.
Okay. Did you open his door then?
It appears from the studio. I mean, I saw his hand move over to it. You can kind of see.
That's what I thought too. So I wasn't referring to that one.
Okay, you weren't referring to that one.
Okay, so you can keep going.
What's going on, man? So we got
Nobody over here. I've been in this car this whole time since they've been in the party.
No, fair enough. So hold on. Whoa. Hey. You're in a park after dark. I need you to identify yourself. So hold on. You are currently.
Why are you opening the door? So
Yeah, you ain't listening to us. Okay, listen.
So the back door just opened, the rear passenger door. Is he seated in the rear passenger door?
He's not seated in the rear passenger.
What made you open the rear passenger door?
So I didn't open the rear passenger door. That was an officer that was behind me that had opened it up.
What officer was behind you?
I believe it was Officer Traverso.
you back up? I'm trying to see the vantage point from the camera.
Nobody over here. I've been in this car this whole time since I've been in the party. No,
fair enough. So hold on. Whoa. Hey. You're in a park after dark. I need you to identify yourself. So hold on. You are currently.
Why are you opening the door?
Yeah, well.
Whoa,
you ain't listening. Okay, listen. Hey,
It does appear that someone else came behind and opened the door.
Yes.
Another officer. And you would have no clue why that officer opened the door.
I mean, I wouldn't say as to why.
Okay. Redirect.
None, Your Honor.
Any recross based on my questions? Okay. Thank you. Thank you. Maybe excused.
Thank you. Already signed.
Oh, well, you're good to go.
You can call your next witness.
People know other witnesses.
You have no witness.
You can proceed to argument.
Your Honor, after seeing the proofs today, based on the evidence that came forward, that people do not feel like we have enough to move forward with these charges. And the misdemeanor attached to this file also would be fruit of an unlawful seizure. So we would ask that that charge is dismissed as well.
Case dismissed.
Thank you, Your Honor.
Thank you. We'll get you a dismissal.